Good morning again. Welcome to our 9:45 session adjudicating the PCI process, or the PCI adjudication process. One of the stickiest areas in handling cyber claims is around PCI. I know the underwriters in the room have learned a tremendous amount about the process over the past year and a half, either in a good way or a bad way. The panel will be spending an hour on it this morning, led by Dave Nevada. Dave, you want to take over?
Thanks everyone for joining today. We're going to talk about the process by which merchants essentially get hit with fines, penalties, and assessments, which we'll talk about what that means in a bit, after a payment card breach. And we've done this panel before. Today we're going to do it a little differently though. We've set up a scenario-based approach. We're going to walk through kind of a tabletop scenario where a breach has occurred, and each of our panelists, who are going to introduce themselves in a second, is going to play a particular role in the breach. And so at this point, we have the panelists, each of them introduce themselves and tell you what they're going to be doing in this breach scenario.
My name is Mark Schreiber. I'm from the Edwards Wildman firm in Boston, and I chair our Privacy and Data Protection Group Steering Committee. I'm going to play the role of the lawyer, or at least one of them here.
I'm Viraj Sani. I'm with Willis. I'm based out of New York, part of the cyber team, and I'll be playing the role of the insurance broker slash claims admin.
Good morning. My name is Ernie Liu. I work for a cybersecurity firm named Mandiant. Today I'll be playing the role of the third-party investigator.
Hi everybody, my name is Grayson Lennick. I work for Nuix North America. I'll be playing the role of the evil PFI investigators out to kill off our clients. And you'll notice I'm purposely as far away as possible from the lawyers.
Terrific. All right, so let's get started here. So, first issue is laying out the fact pattern here. So we have a company called Never Breach that runs an e-commerce site selling its various goods. It's not a very big company. It does about 30,000 transactions a month, credit card transactions. They use a web server that is hosted by a third party called Clouds Are Secure. The site utilizes an e-commerce platform and shopping cart developed by a company called unsecuredcoding.com, and they're the application providers. Unfortunately, Never Breach has never actually looked at or vetted out the software at issue in this case. Never Breach is a merchant agreement in place with a payment processor and a merchant bank. I am on your side as the processor. The merchant bank has passed it on. And the site conducts approximately 30,000 payment transactions a month. Never Breach does not store any payment card data on its systems currently. It's wiped all that data. And Never Breach has cyber liability insurance that includes coverage for PCI, fines, and penalties with a sublimit of $250,000. So that's the basic setup here going into the situation. On February 28, 2015, Never Breach receives a letter from its processor indicating that Visa has discovered that may be a common point of purchase, that there may have been credit card fraud on its site. Visa's requested an investigation, not a PFI investigation at this point, but its own internal investigation into the matter. So I want to talk about what's happening here and what would happen with respect to this situation once the merchant gets this information. And we'll start with Mark. From a legal point of view, how are you getting involved in these matters, and what are you telling the merchant at the outset?
So when the call from the client first comes in and you hear facts of this sort, you can anticipate a cascade series of events. You know there's some card intrusion, you know there's some fraud, you know the PCI rules are going to apply. First set of questions to the client are, so what have you done? Have your IT people help contain this? Are they doing it on their own? Have they engaged a forensic investigator? Do you need help on that? And then as you begin to have those discussions, you also want to tell the client to put the insurer on notice, and do you have any kind of cyber risk coverage? Because that question will also dictate who pays, and who pays all of the people in this chain of events that's now going to occur.
Yeah, just add to that on Mark's comment. So on the first slide, we did say there's PCI coverage, and in some cases the insured may not have that coverage. It's typically done by endorsement and sublimited. I'm assuming in this case we just got the account, so it's some limited to an amount which may not be sufficient in this case. But so that's one of the things to be considering when there is PCI coverage, that it may not be in all insurance policies. It's an endorsement, it's an insuring agreement, but it's something which covers for those fines and penalties, and we'll go later more into that as to what that really means.
Grayson and Ernie, there's sometimes a tension between the merchant's efforts in remediating the breach versus forensic preservation of evidence and information that could be helpful to defend the merchant against credit card brands and lawsuits and otherwise. Can you talk a little bit about what happens sometimes in these cases?
Yeah, sure, I'll take that one. So in most cases, small merchants, especially somebody like Never Breach that's running an e-commerce website, in many cases they're not going to have any kind of internal IT staff or even a web developer or anything. They're going to count on third-party providers to provide this kind of stuff. And they're a dime a dozen. They're out there, they're everywhere. And most of them don't have any kind of formal training or any real knowledge about how to perform an investigation. So in most cases, unfortunately, their first thought is to wipe the systems down to bare metal, not keep any copies, restore the site from a backup, and off they go, destroying evidence in the process.
And I would just add to that, some of the dangers of, and we're calling this remediation, Grayson said, stripping the system down to bare metal. Some of the danger in not preserving the data is in terms of the investigation, not understanding how the breach occurred in the first place. If we equate it to a crime scene, you're basically trampling over evidence.
And from a legal point of view, I'll say the evidence we're gathering here is crucial in terms of how big the breach was, how many cards were affected, because those figures actually end up dictating whether or not assessments are going to be levied against the merchant. And we'll get into some of the detail on that later. But without the evidence at all, oftentimes the worst will be assumed by the evil PFI. Tell us that later as well.
Yeah, and part of the goal here is to begin to establish the facts, or at least the most favorable facts, as soon as possible. So we'll talk later about the tension between engaging your own forensic investigator and the PFI and who's going to pay for what, but our position usually is get your own forensic investigator in as soon as possible so they will be on your side. You can at least control some of that flow of the information, and you can also, at least to an extent, exhibit or have an umbrella privilege over what the forensic investigator is telling you.
Okay, so we've gone past the initial discovery. Now we're going to talk about the investigation forensically. So Never Breach has done its own internal investigation and has found some unauthorized access to its systems, which occurred in their mind, around February 14, 2015. That day, March 1st, Never Breach disabled its shopping cart application and reroutes its payment processing to PayPal, so there's no longer any kind of risk that the shopping cart is being scraped with credit card information. And then that same day, Never Breach receives another communication from a different card brand. This time it's MasterCard, identifying Never Breach as a common point of purchase. And MasterCard is not saying do your own internal investigation. They're saying you need to hire a PFI investigator within 48 hours to determine what happened here. So now the serious investigation is beginning with respect to forensics, and a PFI is coming on the scene. Grace, can you tell us what the role of the PFI is and how they go about their investigation and what limitations may exist in that investigation?
Sure. So a PFI is a PCI forensic investigator. There are groups of forensic investigators that are specifically certified and companies that are specifically certified to work payment card breaches. There's no real difference in the training, the forensics training or anything like that. What's really different about a PFI investigation and a third-party investigation is the scope. And PFIs are encouraged, not only by the merchants, the processors, and the card brands, to focus directly on payment card data. So most cases, PFI is not really going to take a very holistic approach to a merchant environment. If we know that there is a single web server and a single database server that handle cardholder data, that is going to be the scope of our investigation. We're going to find everything we can. We're going to do forensic evidence recovery and storage, We're going to use that evidence to find out what happened to the cardholder data. And in many cases, that's where our investigation ends. That what you're looking for?
Thank you. So Mark, quick question on this. In the past, PFIs have been potentially viewed as more working in for the benefit of the card brand maybe than the merchant. Can you talk about potential conflicts of interest and issues that arise using a PFI and how you might remediate some of those issues?
The PFI role is, as Grayson said, a very structured one. They have a set of rules, they have a set of criteria, they have a formatted type of report which, among other things, at some point tees up the PCI violations and connects them to the breach. So the little checkbox is what caused the breach. That is a different function than a forensic investigator of your own who will look at the panoply of the network or whatever else might have occurred in the intrusion. There may be other data, other PI beside card data. The forensic investigator of your own is not drawing conclusions about causation in the same narrow or directed way that the PFI is. And the forensic investigator of your own may have a different view of causation or a different way of looking at the same facts. So the tension, whether it's a conflict or not, is an important one because, as you will see in this scenario, the outcome of the forensic investigation may determine the outcome of the case and potentially, in this situation, the survival of this particular small company.
I think I'd like to add real quick that there's a reason that the scope is much more limited, and there's a reason that PFIs are encouraged to keep that scope down, and that reason is cost. Unfortunately, when we're talking about small merchants, the majority of them are not insured. They don't carry these kind of policies, and that's why the PFI companies have been encouraged to keep the costs and the hours down any way possible so that merchants aren't being further punished by a process.
I think I'll just add to Grayson's point. So the PFI, I mean, their allegiance is towards a card brand. So whenever they are doing investigations, their allegiance is to find something in the network and the breach happens. And we will talk more about the independent investigator who would further go deeper outside of the scope of the systems, which might be outside of the scope of what PFI is supposed to do, because they are more audit mindset and investigator would be more a forensic mindset, looking at the systems holistically. One more point on the policy side, it's not always a target type of breach. It could be small retailers also where you have a breach. And so access to these services, whether it's PFI or whether it's forensic investigator, is a huge benefit to the insurer at that point because they can access the breach code of those folks in a timely manner without just getting too late overall.
And the PFI report may not be a privileged document. There are arguments that there's a joint or common interest with the card brands. The PFI report goes to the card brands and goes to the merchant, which means you automatically have a triangle, and whether the lawyer-client privilege applies to that with respect to discovery in some third-party lawsuit, I think is unsettled.
And that's a great point, Mark. I think that's one of the advantages of having the third-party forensics, third-party investigator, is that their findings, again, are more of a holistic approach, understanding what went wrong and other areas for improvement. And more importantly, that report does not necessarily need to leave the house. It's really targeted at improving and actually helping the small merchant.
The next slide here. So, as part of the investigation, we had some forensic findings. The forensic assessor finds evidence that the site's code was modified, allowing hackers with IP addresses from Vietnam to write a script to capture payment card data in real time as it's inputted by the users into the card itself. So no stored data, but actually real-time capture. It appears the hackers first gained access to the server on January 1st, 2015, 2 months before the discovery. However, evidence suggests the script was not installed until February 1st, 2015. So access earlier, but the script didn't start running until later on. There have been dump files found. So the hackers got in, started scraping card data and putting them into zip files and other types of files that are found on the server that they come in and take off the server, and used for fraudulent purposes. So all of this has been found as part of the investigation. And so I'd like to have Grayson and Ernie talk about this type of attack. This, I called it an epidemic during our setup here, and I said, well, maybe it's not an epidemic, but Grayson corrected me. He thinks this type of an attack and this type of methodology of attack is an epidemic when it comes to credit card breaches. So maybe we get a little bit of insight on what's happening there and how the hackers are actually doing this and how it works.
Sure. So, I mean, just from the tagline here in that first line, the line that says, code was modified allowing hackers with IP addresses from Vietnam to install a script. Just from working so many of these cases, I know from experience that the crew that works out of Vietnam primarily attacks servers that are running Adobe's Cold Fusion product. And that's just one example of the thousands of vulnerabilities that are out there in websites and web code. Versions of Cold Fusion from its inception, from version 3 through I think version 10, which is last year's version, are vulnerable to a number of different types of attacks that allow a hacker to gain administrative control and upload files to a server. And once they've got files uploaded, they'll usually upload something like an administrative shell, and off they go with the ease of using a web browser to control your server, modify code, and do whatever they need to do or want to do with your system. So, Ernie?
And we talked about the word epidemic. I think in general attackers are, for lack of a better word, lazy. They'll take the path of least resistance. So once a vulnerability is identified, let's say on a Cold Fusion, as Grayson mentioned, or a WordPress or Apache web server, the attackers don't spend the effort to look for a new vulnerability. They'll just look for who else is vulnerable to this defect that I've already identified, and let me just hit those people. They're very opportunistic.
Or were. I mean, now we're starting to see the targets and the Neiman Marcuses and the PF Chang's, where I think the soft targets have more or less dried up, right? We're done seeing the single Burger King being breached. We're done seeing, one little barbecue joint getting smoked, or a little bar. Those targets dried up. They've already hit them over the last few years, for the most part. They're always going to be out there. There'll always be new businesses coming online. But when that pool dries up, they look to the next target, and the next target is, well, Target. No pun intended. Or maybe it wasn't.
And what we're actually now finding is that a number of these more sophisticated attacks are targeted ones. Small t, very sophisticated, unique software, having identified a vulnerability of some company.
Certainly, I think in the sense of large-scale compromises, those are definitely targeted. I think in the case of perhaps our study here, never breached, it's more than likely just opportunistic.
Agreed. So getting deeper into the forensic findings, we have a situation where we see a timeline where unauthorized access was discovered on the 1st of January 2015. The script was not installed until February 1st, 2015, and then the breach ended when they shifted to PayPal for payment processes on March 1st. So I want to get an understanding from Grayson and Ernie how a PFI investigator may judge this breach in essence and how big it is versus the independent forensic investigator. And again, remember, 30,000 cards are being processed a month, and so when the breach starts and when it ends impacts the number of cards that are affected and how much fraud potentially, and Mark will get into this, may have to be paid out by the merchant. So Grayson, how would a PFI look at this situation in terms of the scope of the breach?
Sure. So we've got pretty conclusive evidence here, right? We've got we see the unauthorized access in the logs. We see the server actually being hacked. We see a script being placed, and we see evidence that that script has actually successfully aggregated cardholder data. And then to top it off, we've got the common point of purchase data that also reflects cards used inside that time frame, showing fraud. At this point, this is pretty much a slam dunk for a PFI investigator. This site was hacked. Code was modified specifically for the purpose of scraping cardholder data, and that cardholder data that was then removed and probably sold on the black market, where it was in turn resold and used fraudulently. Pretty simple, right? But there are 3 windows that the card brands specifically ask PFI investigators for. One is the window of intrusion, one is the window of exposure, and the third is the window of system vulnerability. The third of those being used by the card brands mostly to point at your clients or your merchants and say, see, the investigator says you are vulnerable to this from the time you set up Cold Fusion, neener, neener, neener. And then the window of intrusion starts when the attacker first got access to the system, where the window of exposure should reflect when cardholder data was actually beginning to be scraped. The problem is that there are a lot of PFIs out there that don't pay enough attention to those 3 windows and will regularly or almost always match the window of intrusion to the window of exposure, with the thought that, look, they were in there, they likely were actually gathering cardholder data for that entire period. So you get a window of intrusion and a window of exposure that covers January 1st through March 1st.
And Ernie, how would you look at it from an independent forensic point of view?
You know, as Grayson mentioned, I think the fact-finding would be very similar in terms of process. I think where the major differences might be is in the interpretation of the data. You know, an analogy in my head is kind of like a second opinion from a doctor. You know, medicine is a science, but if you get a terrible diagnosis, you're probably going to want a second opinion. Similarly, a third-party forensic, somebody on your side, such as a third-party forensic investigator, might have a different approach to interpretation of the data and limiting those exposure windows down to something that might get this merchant underneath those thresholds, those card thresholds.
I've seen cases where between that January 1st and February 1st area where you can't tell what really happened in that case. And some PFIs will say, well, just because the script looks like it was first installed on February 1st, there may have been a different script on there that they took off, or they may have been modifying logs to cover their tracks so that you didn't detect them during that time frame. So therefore, we need to assume that the breach happened earlier. In contrast, I might, as a lawyer, say, no, the only actual forensic evidence is the script started on February 1st. That's the start date of the breach. Therefore, the cards that were processed in January were not exposed, and therefore not subject to the card brand rules. Mark, can you talk about how the card count factors in
Sure.
the ability of those rules?
As you can see from this example, on Visa, the number is 10 less than 15,000. And 15,000 is the cutoff under the new, or relatively new, Visa minimums before the expense and the fraud-related assessments kick in. So you're under 15,000, you don't have those numbers applied to you. You're over 15,000, you do. And as we go on in this scenario, that will make a significant financial difference. The same thing applies with respect to MasterCard. If the window of exposure is such that, in fact, it's 9,985, we're 15 below the 10,000 MasterCard minimum. And same thing with American Express, although the numbers are a little different there. So this whole notion of looking at the facts, of exploring with a forensic investigator the best case scenario, and the arguments to limit or at least address the window of exposure is critical in the final number calculation, particularly for PCI fines, assessments, and the like. So that a good forensic investigator, let's say like Mandiant, may find signatures of this type of malware. They may be able to tell you particular factors about them that'll be useful. They may be able to help in some other construction that the PFI didn't look at.
Thank you for that plug. $20.
They're all good. Yeah. All right. So, Mark, can you talk about what are the fines, penalties, and assessments? Now, the Never Breach in this case now, much later, receives a letter from its processor indicating that they're being fined $5,000 for not being compliant with PCI, and that's going to continue every month until they are compliant. In addition, they receive another letter from the payment processor from Visa saying that there is an assessment that's being levied for operating expenses in the amount of $50,000. That's there are 20,000 cards in this case, $250 a card, and a fraud amount of $2 million. So what's happening here? What are these fines and penalties? As a lawyer, how are you trying to defend and help your client avoid these onerous costs?
These numbers go to the heart of establishing the facts and the forensic issues we just talked about. If we are over 15,000 in terms of card numbers, then the Visa fines, penalties, and assessments are going to cost this client in excess of $2 million. This is a relatively small merchant. They can't afford that. Probably end of story for their business. If we can convince the card brands or the processor or the First Datas or whomever that the window of exposure ought to be that shorter period, arguably we're back down to $5,000 for non-compliance and maybe some other nickels and dimes. A manageable situation so that the forensics are, as we started out in this scenario, absolutely critical. And an in-depth, microscopic, granular assessment of anything you can do in that regard is the direction you want to take the arguments with the card brands or the card processors, because you will have an opportunity, so to speak, to negotiate in quotes. There is an appeal procedure, but appeal in quotes. But the merchant does not have a lot of leverage there. What you do have in this scenario are facts on your side. So I don't know if any of the other folks want to talk about how that process develops.
Yeah, I just wanted to mention that, I mean, the scenario that we're using, we've pitched a bit of a softball out there, right, where there's a month in difference between the window of intrusion and the window of exposure. Dave and I have had the pleasure of working together on a handful of cases, and one in particular kind of spurred this kind of scenario. And it wasn't a matter of months or weeks or even days. In our case, it was a matter of about 14 hours. In my report, I stated, the date February 14th as the end of the window of exposure. Well, it turns out that window of exposure ended at 10 a.m. the day that I was there on site with that client, found the malware and removed it. My window of exposure still went through the end of that day. The card brands calculated the number of cards that had been processed through the end of that day, and they were over by about 26 cards. So we're talking about the difference of 26 cards, meaning the difference between a couple $1 million in fraud recovery and a simple fine for PCI compliance, and the card replacement costs. So it really does, in some cases, come down to hours and minutes, and that's why the forensics piece is so important.
Yeah, there's one claim that I worked on which went for actually a couple of months, and in that case it was a small retailer, the common point of purchase, that's where the breach happened, and the card brand saw on analytics that there's some fraud going on from that merchant. They went in and the PFI came in, and there was no claim filed till much later until the PFI did not find anything. And then the investigator, forensic investigator that came in, started doing the rest of the investigation to find out that the breach was outside of the scope of the point of sale side. It was in one of the servers. But the point in that is, does the policy pay for two forensic investigators? All policies do not. So you want to make sure on the voting side, when the claim comes in, that the second investigator is being on site. Is that something that would be covered or not?
And from the company's point of view, that additional cost, either of the forensic investigator, which is independent, or the PFI, to our minds ought to be less significant, because the outcome in these cases is, as we've discussed, going to depend on these microscopic details. And the variance of how you make the arguments to try to get the PFI to change its language in the report, to add an additional phrase about the window of exposure, to discuss the probabilities of what that software type or malware variant exhibited are important. And from that additional sentence or two or paragraph in the PFI's report, which they often will be willing to modify, can become extraordinarily important. So the PFI will give you a draft of the report beforehand, allow you to comment on it, and maybe Grayson, you can talk about how that dynamic works.
Yeah, it's it's really kind of interesting because again, most merchants are uninsured or carry minimal insurance. Most small merchants also don't have some kind of counsel on staff. So it's actually the rarity that I'm actually engaged with counsel from the beginning. Normally, counsel is engaged well after the fact. You know, when they get the letter that says, "Hi, you owe us $2.5 million, and we're now going to hold 100% of every credit card transaction that you make for the next 5 years." That's when they get a lawyer. And unfortunately, at that point, we're well down the path. My job as a PFI has now been done for 10 months or a year. I've already destroyed the evidence from that case that was in my safe for the requisite year, and then we're really left sort of with the report being the report. And
yeah, and if that's the case, then this merchant is in some real difficulty.
Right.
So
right.
our goal as counsel is get in there as soon as possible, get your own forensic investigator, whatever it costs, as quickly as can be obtained. Argue if you have to with the insurer about the need to have the separate forensic investigator paid, because that will ultimately reduce the exposure to the insurer as well.
Yeah.
Is the evidence always destroyed, Grayson? I didn't realize.
Every company has its own policy about data retention. The card brands themselves mandate that data will be saved for at least 1 year. And most companies, after that 1 year, it's very expensive to have an evidence repository and to keep evidence for a long time, to have a person that's their job is to handle evidence. So most companies, including my prior companies, destroy the hard drives that contain that evidence after 12 months.
So to go back also to the other exposures in this scenario of the merchant, we've just mentioned the Visa fines. You also have MasterCard and to some extent Amex or Discover. So the $2 million plus is not the only portion of the PCI fines, assessment, and penalties. It could be double that. And there may be other claims, as we know. You've heard enough about plaintiff class actions, but there may be other financial entities who will want to pursue the merchant. So there are a couple of new cases recently filed by credit unions alleging that they're outside of the PCI structure and they can bring their own claims against the merchant for cost of replacing cards and the like. So this whole cascade of events is now beginning to unfold from that first call of this merchant earlier in the scenario.
All right, so we'll anchor it here with Niraj talking about some insurance coverage issues. So at the outset of the breach, Everbridge notified its carrier and they were receiving coverage for the breach notification costs. One thing to keep in mind here, we've been talking just about the credit card response and trying to fend off liability around the credit card companies. At the same time, Mark or whoever is involved in this case is dealing with providing notice to all the affected individuals. So this is all happening concurrently. So this, we didn't even get into that part of it, but they're covered for that. Now they've also, Everbridge has also in this case requested that the carrier pay for Mark's fees to defend the claim that hasn't been made yet by Visa, so that Mark can hopefully reduce the liability of the insured in this case. Now again, Niraj can talk about it. Most policies have our claims made coverage, so triggers. It has to be some sort of claim, third-party claim. Here, the claim from Visa or MasterCard wouldn't happen until 6 months, maybe a year later, when they send that letter seeking the $2 million or what have you. And then finally, there's an issue around fines, penalties, and assessments. And Everbridge is requesting that the carrier pay for the fines and penalties and assessments. So, Niraj, what are there coverage issues here we need to worry about? There's a letter coming to the insured. What's that letter going to say, and how are you dealing with it from the broker side?
Yeah, so there's few issues. So let's start with the notice. In typical merchant, when a breach happens, they just have a magnetic stripe of the card and the name at the most. They don't really have the address of the person who comes in the store. So it'll be more a substitute notice. If they do send the notice, it'll be like the 3 things you need to do: a media notification, something, a link on the website, and that'll be the notice in that case. If it's an issuing bank, they'll be sending the cards out for replacement cost. So there'll be a letter going from the issuing bank, and there'll be no content on the breach. So the notice is the substitute notice from the insured, from the merchant, that'll describe as to what happened in this breach. And they'll kind of go into the cause depending on the state. So each state will have a different notification requirement that way. As regards to the legal expenses, they've said there's no suit yet. There's card brands are still working on as to what the damages are. So how does the policy respond to that? Until there's the suit against the insured, all that's getting paid at that point is really breach coach cost and the forensic investigator. And if there's one forensic, then it's just the one forensic investigator. So that's one limitation. There's some policies that don't have the plural on that. And the third thing is when the card replacement has happened, the issuing bank would come back again to the merchant, or they could go through card brands. There hasn't been much success right now where a big bank would go back to the merchant and say, we reissued these million cards and you owe us money for the card replacement. Not much luck there. So they may go to the card brands and say, can you settle on our behalf for whatever the cost is? And in that case, that'll be like 6 months down the road or a year down the road. The card brands could come back to the merchant again in the form of assessments. So there's fines and penalties, which is their non-compliance with security, and then there's assessments, which may include fraud charges, card replacement costs and such. And like Grayson said, that could just taken out from their account, like a chargeback. They didn't really have much control on it. And how does the policy respond? Because the definition of assessment is defined by PCI. Policy does not define what assessment means. It could be saying PCI, fines, penalties, and assessments, and more, and expenses. So it depends on what bucket does that cost fall into. If that's a sublimited cost, like in this case $250,000, that might not be enough to pay for all those costs. There are some policies that have full limits, but the idea is you need to know which bucket that cost would fall into. I think it should be liability, but in some cases it may not be, depending on how PCI is defined in that case.
Okay, so I think we're coming to the end of our talk here, so now we're going to do some quick takeaways, and then we'll take some questions. So, Grayson, you want to start off?
Sure. So quick takeaway is the earlier that the client is engaged with legal counsel, especially legal counsel that knows what they're doing and talking about, the better the outcome for the merchant. And honestly, I feel the better the outcome for the forensics teams as well. We're not trained lawyers. We, in many cases, until we've done some of these cases with good legal counsel, we don't really understand the impact of our writing and our reports until we get a chance to work on a case like this. So I think it's very, very important to get good counsel at the beginning, at the outset of one of these. It makes everybody's job easier, better, and honestly less expensive.
Mark?
This is a mutual compliment, but the earlier the forensics are involved, the better. We've been going over that message now several times, but it's going to become even more important with the new PCI 3.0 rules that are starting to kick in as of next January, and in this scenario would have already been in place. So what we didn't get to are all the additional obligations this merchant is now supposed to be adhering to, including vetting the sub-processors and everybody that touches card data. The small merchant had no clue of that. As we get into next year, whole new ballgame, and I would expect PFI reports now to be addressing PCI violations under the new rules. There are going to be a lot more checkboxes and a lot more causation and a lot more numbers attached to that.
I think I'll keep it simple in terms of knowing where your risk is, where your data is, and have a vetting process before the breach to know which vendors would be working with you in the event of the breach. So I think that's one of the benefits that you have if there's a cyber policy, that you have access to these vendors. So know that before the breach rather than learning on-job training at that point. So, yeah.
And I would just add to the common theme here is that the victim merchant starts out at a disadvantage. So whatever actions they can take to help increase their chances of again, a more palatable outcome, the better. And the critical phase is as soon as they're notified of suspicious activity to take action and involve the proper parties, whether that's legal, get in touch with their insurance, and involve a separate investigator if they don't already have that in-house. It's kind of planting the roots of a successful outcome.
So my takeaway, again, same theme, knowing how the card brand rules work when it comes to assessing fines and penalties assessment. Knowing that there's a 15,000 threshold for Visa, for instance, ahead of time. If you're going into this blind and you don't know how the rules work on the back end, you may not be able to have the investigation go in a way that helps you out to avoid some of these fines, penalties, and assessments. Now, unfortunately, you have to know not only Visa's rules, but MasterCard's and American Express's and Discover's rules, and those are like 1,000-page documents you have to sift through, and they're very complex and actually sometimes contradictory within the document themselves. But if you don't understand how those fines, penalties, and assessments are at some level calculated, then you can't really do your job on the front end to try to avoid the risk and the liability on the back end. So that's my takeaway. So do we have time for questions still?
Yeah, take a couple.
Any questions?
Yeah.
Dave, Rennie Muzzy, I have a question for Mark and Niraj. When you're talking about the assessments, particularly when the card brands may come back for the reissued cards, and you're questioning whether it was an assessment, sublimit, or liability. If you go back to one of the original large breach cases in TJX, they were actually sued, as I understand, by a consortium of banks to recover those fees. Is that kind of what's changed, where you might now see this as an assessment as opposed to where it was in that case kind of a consortium of banks suing TJX?
That TJX wasn't quite based on the assessment notion, and it ended up, as I recall, being dismissed on some of the pleading elements of negligent misrepresentation and whether TJX had actually made misrepresentations in public statements. So it never really got to those critical questions about either the PCI structure or the flow-through or the chain of entities within the process. The new cases, on the other hand, that are coming out are going to get to that. There's a case against Home Depot by First Choice Federal Credit Union and one Wins South Credit Union against Mapco Express. Both of those are class actions on behalf of financial entities. I mean, almost unheard of. It's as if the credit unions are taking the plaintiff class action theories, morphing them into another set of class action claims on their behalf against merchants for similar kind of issues. That is, they're outside the loop, and that also gets to some of the assessments. But,
I'll just add, yeah, the merchant services agreement between the merchant is with the acquiring bank, the processing bank, not with the issuing bank. So the issuing bank doesn't really have any relationship with the merchant to sue them. They can sue them, but they won't get much successful. So what happens is they go to the card branch to say, you have a relationship with the acquiring bank, so can you help us in that? So that's why that chain is more successful than the issuing bank going directly for the merchant. So that's what I've seen.
A couple points. So one thing to know, the chain, the PCI credit card rules, brand rules, don't make these issuing banks fully whole. As a matter of fact, they probably give them 30 cents on the dollar in terms of money back for fraud and reissuance. So I think it's kind of a full circle happening here. At first, they were trying to sue and they were unsuccessful. So the card brands created these new rules to give them some money back. But now some of the credit unions are saying, this is not adequate compared to what we actually lost, we're going to sue again. So that's kind of where we are in this cycle.
You make a quick one? And a quick answer?
Amidst everything that you're seeing these days, do you see any growing body of evidence of payment processors who are doing a poor job of serving the merchants?
I think the payment processors are required to make sure that the merchant's point of sale devices are secure, because at the end, they are the ones who will be holding the liability. The merchant goes belly up. So, I mean, I can't generalize as to if they're doing a good job or not. It depends on the payment processor.
Well, maybe from a statistical perspective, in many of these investigations, do particular payment processors start recurring over and over and over again in terms of being part of the environment?
The question is, are there certain payment processors who are repeat offenders when it comes to this situation, and are they serving their merchants adequately when it comes to these breaches?
Well, this is kind of facetious, but I think the answer is yes and yes. They're all being hit. So there isn't really any one payment processor that's doing it any worse than the others. They're all doing it poorly. And I mean, it sounds kind of funny, but it really is the truth. There's a handful that actually encourage their clients to go through the PCI checklist at least and turn in the checklist and the basic external vulnerability scans. And if they do that, and if they report compliance to the processor, they're actually offered a minimal insurance policy to help cover the cost of breach. So there are a couple that are doing it right, but the vast majority of them are just making it easy for people to process payments. That's what they're in business to do. Good question.
Thanks everyone for your time, and I hope you enjoyed it.